Here's the third article from the Washington Post from MSN, and it says the president can't obstruct justice. That's not quite right, legal scholars say. And this is from Matt Zapotowski. He goes on to say the assertion by President Trump's lawyers that he cannot obstruct justice because he has absolute authority over all federal investigations is legally problematic. Analysts say because it would essentially mean the nation's commander-in-chief is above the law. But the president's powers are expansive, and many questions remain about how Trump's office could protect him from the special counsel investigation, examining whether his campaign coordinated with Russia to interfere with the 2016 presidential election. The fact is, everything we are seeing, there is no precedent for it, said Jacob Frankel, who's worked in independent counsel's office in the late 1990s, and is now at the law firm of Dickinson Wright. So subscribe to both newsletters and possible there. The 20-page letter submitted to the special counsel's office this year. Trump's attorney asserted that the president's actions here, by virtue of his position as chief law enforcement officer, can neither constitutionally nor legally constitute obstruction of justice, because that would amount to him obstructing himself. They also asserted that he could, if he wished, terminate the inquiry or even exercise his power to pardon if he so desired. Legal analysts said that as the head of the executive branch, Trump could issue pardons. Fire senior officials and order them to shut down investigations, but his motives were corrupt. Such actions could constitute obstruction. The principle laid out in the letter is a ludicrous legal theory, said Neil Cahill, a former acting solicitor general who now works in private practice at Hogan Lovells. The idea that a president can't obstruct justice died with King George III, with a brief attempt at revival by Richard Nixon. Letter signed by lawyers John M. Dowd and Jay Sekulow was part of a bid to keep Trump from having to sit for an interview with Special Counsel Robert Mueller III, especially on questions about whether he obstructed justice. Attorneys asserted that Mueller's team had ample record upon which to base your findings on no obstruction, and thus there's no need for the president to talk with investigators. This memo is a polite way of taking 20 pages to say he's not coming in without a subpoena, and even then, you're in for a protracted fight, said Frankel. Frankel said, says here, Mueller is exploring whether the president meant to thwart law enforcement by, among other things, asking the FBI Director James B. Comey not to pursue a probe former National Security Advisor Michael Flynn, firing Comey and pressuring Attorney General Jeff Sessions to either resign or take command of Mueller's probe. Sessions recused himself because of his role with the Trump campaign. The letter aimed to rebut each piece of the case. Lawyers asserted that Comey's firing was justified because it was recommended by Attorney General and Deputy Attorney General. They wrote that Trump disputes have told Comey to let go of the Flynn investigation, What does it say? And that even if he had, the president could have intended to obstruct justice because the White House had indications that the Flynn investigation was not ongoing at the time. The lawyers also made the technical argument that an FBI investigation, unlike grand jury investigation, did not count on the law as the proceeding. That could be obstructed. But that seemed to overlook the 2002 law that makes it illegal to obstruct even proceedings that have not yet begun. Many legal issues the president's team raised have little precedent. Legal analysts said no president, for example, has ever tried to pardon himself. Rudolph W. Giuliani, attorney for the president, said during television appearances Sunday that while Trump probably had the power to pardon himself, he had no intention of doing so. The move, Giuliani said, could spark impeachment proceedings. Jonathan Turley, a law professor at George Washington University, said he believed the president had the authority to pardon himself, using pardons as a piece of an obstruction case that might be problematic because of the nature of the act is to bar prosecutions that set aside convictions. Quote, that has been something of a parliament for constitutional scholars for years, and many of the fun hypotheticals that we've used to enjoy over beers all seem to have been coming to fruition under the Trump administration, so he said. Judge Sugarman, Fordham University law professor, said raising the idea of pardons could be read as a warning to Mueller that if he pushes to subpoena Trump, the president could escalate the fight by pardoning people under investigation. There's a real practical consequence for the Republic if Trump is able to win the silence of the other defendants with the use of these pardons, Sugarman said. Quote, if he's making an implicit threat that he could escalate this with pardons, there's nothing in the letter to indicate that he's not willing to pardon himself. It is unclear, too, whether and to what extent Mueller might be able to compel Trump to testify. If the president will not agree to a voluntary interview, by virtue of his office, the president does enjoy special protections. The Justice Department had twice opined that the sitting president cannot be indicted. And Giuliani said, and Mueller's team conveyed, and Giuliani has said Mueller's team conveyed to the president's lawyer they will honor that guidance. Those options are not the same as a court decision, nor do they rule out the president being forced to testify. Independent counsel Kenneth W. Starr served President Bill Clinton with a subpoena to compel him to appear before a grand jury, but it was withdrawn after Clinton agreed to testify voluntarily. Trump's lawyers pointed to case lawyers suggesting Mueller would have to show that investigators were unable to obtain the same information elsewhere before demanding an interview with Trump, Turley said, and that because the obstruction hinges on that intent. Trump might have a hard time convincing a judge that investigators could get that information without talking to him. Quote, in issues of intent, there's only one person on earth that can conclusively speak to that issue, and that is the president himself, Turley said. End quote. So if Trump were served with a subpoena, legal analyst said they expect he would challenge it, and the dispute would almost certainly escalate to the Supreme Court. They said that while the courts might unlikely limit what the president could be asked, it was unlikely they would agree with the president's legal interpretation that he cannot obstruct justice. For me, quote, it is difficult to believe that any Supreme Court justice would endorse the right of a president to be lawless, in a sense of being entirely above the application of law, end quote, Frankel said. And that's that article there on the president.